everyone to everyone who's out there to our Thompson Hine's inaugural Startups Streamlined and our monthly webinar series. My name's Lindsay Stencel. I am a partner in the New Ventures practice group and one of the chairs of fund formation here at Thompson Hine. But this week, or this month, I should say, joining me is Anthony McNamara. He's a managing associate in our labor and employment practice group. And so all of us, every time we add an employee that's beyond just us as a founder out there, we have employment issues that are going to start to arise. And sometimes we don't think about those until a little bit after the fact. And the sooner we can think about them, oftentimes, the better for our growing businesses. So today we're going to discuss why it's important for business owners to weigh several factors when establishing their startups, including their legal obligations as an employer. During this webinar, we're going to explore compliance with wage and hour laws, maintaining those pesky personal records. I know it's a pain, but it's important. Best practices for communicating with your employees. And hey, how do we use a severance agreement? Because sometimes we just got to break up, right? So if you have questions or comments as we're rolling through this, we encourage you to drop those in the chat. We'll be monitoring that. Every time we do these, we get lots and lots of questions. So don't be shy with those, because if you have a question, chances are that someone else out there also has a substantially similar question. So we'll try to address those as they pop up and follow on with any questions that we'll follow up with you on any questions that we don't get to during the session. So that's a lot of yammering. That's not what you're here to hear today. We're here to listen to the star of the show, Anthony. So Anthony, why don't you give us a brief intro on yourself, and then we're going to rock and roll into some issues that startups face each and every day.
Thanks, Lindsay, and hey, everyone. It's great to be here. It's great to see everyone and to be part of this program. I think this is fantastic. As Lindsay mentioned, I'm a managing associate in our labor and employment practice group. I'm down in our Cincinnati office. I've been with Thompson Hine for just shy of 3 years. I've been practicing for about 7 or 8. I was at a boutique litigation firm before Thompson Hine, where I practiced labor and employment litigation and a few other items. But my practice has really rounded out since I've had a chance to be here. But it's great to be here. I do a lot of work with the startup clients we have. I see some familiar names on the attendee list, and I look forward to chatting.
Awesome. So I know, Anthony, there's been many a times where I call you in a frantic panic and I say, hey, company XYZ has what might look like some issues between discerning, hey, is this person supposed to be an employee? Are they supposed to be a contractor? Can you give us a quick crash course on thinking about how to classify someone as an employee or a contractor? What documentation do we need, and does state law matter?
State law does matter, and that's a great question, Lindsay. That's a great place to start off. This is something we see across our clients, and really what it comes down to is the question of control. How much control do you as the employer have over the individual? And it can be, a documentation specific matter. We do obviously having an agreement in place that notifies somebody they are an independent contractor as opposed to an employee is important. But state labor authorities, state tax authorities, and the federal agencies will also look at, the facts and circumstances of each case. So, who's providing the tools and the equipment that the individual uses to perform their job? Are you as the company interested solely in the end results of the services provided or the means by which they provide those services? Do they need to be at your place of business to do the work, or can they do it wherever? Are they able to provide the same services for other companies or just yours? The more control that you as the company exert, the more likely the individual is going to be considered an employee. Which then raises a bunch of other issues, right? If you are a company that doesn't have employees to start with, You haven't been paying into workers' compensation. You haven't been paying into unemployment. You haven't been paying employment taxes. Now you've been found to actually have an employee who's been misclassified as an independent contractor. You might have penalties there, and that's in addition to anything you might owe from a back wage standpoint for overtime if the individual's non-exempt, which is something I think we'll probably talk about a bit later. But that can put companies in a world of hurt. And so I think there's oftentimes a desire to make somebody an independent contractor because there's flexibility in it, but it is a very detailed inquiry, and it's something that we certainly encourage everyone to think carefully about before they start that relationship.
So true, so true. Because the penalties for that can be pretty substantial.
Yeah.
And, it's not just at the onset of our business when we're adding people, but those things tend to creep up and pop up too when we get to the sale of a business and maybe folks have been misclassified. And it can ultimately impact the end dollars that we get out of the exit of a business. So, super important to think about. So, you mentioned this concept of exempt and non-exempt employees. Can you give us in layman's terms, what does that mean for the folks that are out there?
So when we're talking about exempt versus non-exempt, what we're talking about is the individual's classification under state and federal wage and hour laws, the Fair Labor Standards Act, and various state laws. What it basically means is the default rule is everyone is entitled to minimum wage and overtime for all hours worked in a work week in excess of 40 hours, unless you're exempt. And there are very narrow exemptions to that rule. So we start with the default being that you're entitled to overtime unless you fit into one of these small boxes. The big ones that we often see in our world are what we call the white collar exemptions. So administrative employees who are the back office employees, managers, learned professionals, attorneys, doctors, accountants, so forth, and some computer professionals and outside sales employees. But even then, it can be a bit of a detailed inquiry. Not everybody who is considered an accountant is considered a professional or even an administrative employee. There's kind of two components. We look at one, is the individual paid on a salary basis as opposed to an hourly basis? Are they paid a guaranteed rate regardless of how many hours they work in a week? But that's not all. We also have to look at what their duties are. What are their job responsibilities? Do they have the requisite amount of independent judgment and use of discretion with the job, or are they really somebody who has a lot of oversight in what they do? A lot of times what we see is companies who pay a salary and think that's it, without going through the duties analysis, and that can get you in a lot of trouble too.
So what I'm hearing is the thing that a lot of startup founders don't love to always do because cash is king is that we probably need to think about some of these things sooner rather than later. So can you kind of tell us a little bit about additional things we need to think about in terms of general compliance with wage and hour laws besides exempt and non-exempt employees? If there's anything that sort of pops to the top of your mind that you see folks maybe not get right all the time.
Sure. I think it's important to keep records. Those at the end of the day can be what wins a case for you if you're ever involved in litigation, if you're ever involved in an audit, and I hope none of you ever are. But the more documentation you have, the better off you're going to be. And when we're talking about wage and hour compliance, what we like to see are written job descriptions that clearly identify what the individual's duties are, what the person will be doing on a day-to-day basis. That will help us determine, is the individual properly classified. when we're talking about offer letters, making sure that the offer letters clearly delineate whether the individual is going to be exempt or non-exempt. Maintaining, work records, timekeeping records, making sure that, individuals who aren't supposed to be working over 40 hours a week aren't indeed working over 40 hours a week, because the moment they are, even if they weren't approved to do so, you owe them time and a half for that time. And we also like to see clear employment policies outlining, what the responsibilities of exempt and non-exempt employees are when it comes to hours worked.
Great. Speaking of employment policies, I think that's one of the things that I frequently reach out to you and your group about. So can you walk, anyone who's out there through when you're thinking about an employment policy, what are the things that you're making sure are included in that employment policy so that people know what the rules of the road are?
Sure. There's kind of a few different buckets that we like to look for in an employment policy or in an employee handbook that'll cover a bunch of policies. We want to make sure that we have clear written policies regarding our important employment laws, your anti-discrimination laws, your anti-harassment laws, wage and hour laws like we just spoke about. We like to see clear statements regarding at-will employment, making sure that we're not unintentionally creating an employment contract. It is hard to do, but it can be done. We like to make sure that our clients are not doing that. Making sure that we have our leave policies outlined, that the employees know what the rules are for taking various forms of paid or unpaid leave, and also what's expected of them from a behavior standpoint. What is acceptable behavior? What isn't acceptable behavior? What can give you grounds for discipline or termination? We here in Ohio are in an at-will employment state, meaning anyone can be separated at any time for any reason, with or without notice, as long as it's not an illegal reason. But we also live in a heavily litigious society, and so it does not take much to file a lawsuit or file a charge with the state or federal anti-discrimination agencies. And so we almost have to think about employment as not being at will, and making sure that we've covered our bases, so that way, if and when we're faced with a lawsuit, we have the policies, the paperwork, the trail of documents that show that we really did make the right decision with this employee.
Great. No, I think that's wonderful. So oftentimes in these employee handbooks, employment policies, social media comes into play because we have typically businesses have a way that they want their employees to act, behave, speak of business, things of that nature. What are some high level bullet points that you would recommend people think about? Because I think this is one of the spaces that people do get into litigation on pretty heavily, is that, hey, I said something on my social media account, I got canned, and now I'm suing because they feel they have the right to freedom of speech and things of that nature. So, and they do, but sometimes they don't. So can you talk a little bit about that?
Sure. I think this is a big issue that we oftentimes see. We do. I would encourage all of you on the call to have a social media policy, something that outlines what is and isn't acceptable behavior in social media. Certainly, we don't want to be monitoring our employees' every move on the litany of social media platforms that are out there. But at the same time, we need to protect our own business interests, right? So something that outlines what is acceptable, commenting on something that may be, prohibiting commenting on something that may be private business information, divulging trade secrets or confidential information through social media, prohibiting employees from making comments that could be tied to the company. Oftentimes we see social media policies that would require, in an instance where somebody wants to provide an opinion, which they, certainly have a right to do outside of the employment context. But to say, my opinions are my own, my opinions are not attributable to anyone but me, anything that might, help to provide some distance. But ultimately, at the end of the day, if it is something that could cause you harm, absent an employment contract, it is something that you can discipline folks for. The First Amendment does not cover private employment. But one thing we do want to be wary of as well is that even outside of the union environment, employees do have rights under the National Labor Relations Act, and that will protect what's called concerted activities. So if employees are engaging in any sort of collective effort to better the terms and conditions of their employment, even if they are not, in a union, maybe they're talking about salaries or what they're earning, that's protected conduct. And we need to be careful, even in the social media sphere, of not doing anything that could be seen as infringing on that protected conduct.
Don't pull an employee handbook off the internet machine is what I'm hearing from you.
Yes.
Make sure we actually think about it and review it for the business that is before us and make sure that it achieves our goals. Awesome. So moving right along then, in addition to employee handbook and things of that nature, emotional intelligence kind of plays a role here, as does the law. But what are the best practices that you can recommend in communicating not just policies, but general behavior or discipline, things of that nature, to employees?
I think clear communication is important. I think sometimes we obviously, tough conversations are hard to have, for a reason, but they oftentimes are needed. If we have a problem employee or somebody who's not performing, the best way to cure that is through clear communication. What are the deficits? What can the employee be doing to improve their performance? We oftentimes recommend clients use what's called a performance improvement plan, which is a document that can outline clear, measurable goals that an employee has to meet to get out of probation, so to speak, but to get back in the employer's good graces. But anytime there's a problem that needs to be addressed, the best way to do it is to sit down with the employee and outline what the issue is and what the expectations are. And I come from a background of litigation, and so I'm always looking at this from an eye towards what can keep my clients out of the courtroom or out of costly civil litigation generally. And more often than not, the cases that I do end up having to defend are the ones where a termination conversation was had that it wasn't clearly outlined what the reason for termination was, or there was no review meetings or performance meetings. The individual had no idea there was a problem, and then they're let go, and they have no reason to think it was for anything other than perhaps their membership in a protected class or the one time they expressed a concern about some safety issue. And so we want to make sure that if we're having to have crucial conversations that we're doing so.
Great. So, and isn't that the truth? So, what are your recommendations when you're having that termination conversation? And we'll come to severance in a minute, but what are your recommendations walking into that room, sitting down with the other person? How many people should be there? Who should those people be, etc.?
Sure. So I think there should at least be two other people in the room besides the individual who's being unfortunately let go. There should be whoever's going to communicate the separation decision, whether that be the human resources manager or perhaps the employee's direct manager, but also another member of HR or the management team. The reason that you want to do that is so that way you have a witness. There's somebody in the room who can corroborate what was said. And it's not just a one side versus the other when it comes to, how the communication went down. Um, I think that, this is going to sound a bit conflicting with what I just said, but I do think less is more in the termination conversation. And what I mean by that is obviously outline the reason for the decision, but it doesn't have to be a back and forth conversation. You don't have to provide the individual the opportunity to object or appeal or give their side of the story. It can simply be, we're here today because of X reason. We're letting you go. Here's the reason. So and so will give you more information on your post separation benefits if there are any. And leave it at that. There's no reason to apologize or say I'm sorry that it came to this. That this is part of business, and I think the shorter and sweeter it is, oftentimes employees will appreciate that as well. So oftentimes we have clients who like to use a script. I think that is fine. I'll understand that the script may be discoverable if we end up in litigation, but so just keep that in mind for what goes in it. But a script is fine. Have somebody else in the room and do explain the reason for the separation decision.
Great. So oftentimes with these tough separation decisions, there may or may not be a severance agreement that is presented. So one, talk to us about what a severance agreement is, and then two, tell us at a bare minimum what should be in that severance agreement to get it done right.
Sure. So a severance agreement is a contract between a former employee or a soon-to-be former employee and the employer that basically offers the payment of certain money or other benefits in exchange, usually in exchange for a release of claims. And I say usually because we have had some folks in the past who like to provide severance money without securing a release. So I think the first thing that should be in the severance agreement is an agreement by the employee to release all claims they may have against the company. There are certain claims that can't be released, like workers' compensation claims and the like, but your discrimination claims, your wage and hour claims, anything the employee may have, you want to make sure that if you're giving this employee additional funds as they walk out the door, that you're not going to see them again in a civil action. So number one is going to be the release of claims, and I'll come back to that in a minute because there's more on that. But two, I would encourage folks to consider confidentiality clauses that prohibit the employee from divulging the amount of severance provided. Non-disparagement clauses can be something that could be beneficial as well. Obviously, we don't want to be paying former employees to then go walk around the street and talk bad about the company. And also just making sure that there's a clear statement that we're not admitting any liability. I think that those are the four main things we like to see in separation agreements. The rest of the terms are kind of, to me, negotiable. Those are the ones I always like to see. On the release piece, I want to come back to that quick. One thing we do want to look at as well, and Lindsay, I know you've seen me ask this to clients before, is are we dealing with somebody who is over the age of 40 or under the age of 40? Are we separating them as part of a group separation or just by themselves? And the reason we ask those questions are federal law requires, before we can release age discrimination claims, that persons over the age of 40 be given additional protections. They have to be given at least 21 days, sometimes 45 days, depending on if it's a group separation. There has to be a clear and conspicuous waiver of age claims, and they have to be given the right to revoke the agreement within a week of signing it. And so without those types of provisions, the U.S. Supreme Court has said that you haven't validly released claims under the ADEA. And so that's one of the first questions we ask when we're asked to help put together one of these agreements, because we want to make sure the agreement won't be voided later on.
Great. And I know we're coming to the top of the hour here, and I want to be respectful of everybody's time. But I know some of the other things that oftentimes we need to think about in terms of, thinking a couple steps ahead of, how does this termination appear to the outside world? What are some of the other things that you might think about working with clients on? If they're terminating a diverse female candidate under the age of 40, but are now going to replace that person with a uh, Caucasian male, slightly younger, slightly cheaper. What do you talk to your clients about in scenarios like that?
We will. Yes, optics do play a part, as you mentioned, in discrimination litigation, and this kind of goes back to making sure that we know why we're going forward with this decision. Is it adequately supported by the records? Do we have documentation to support it? Because the first thing that this employee in your example may think is, this must be because of my gender or my race, and it's incumbent on the employer, once that allegation's made, to say no, it wasn't. It was for these legitimate reasons. And so, obviously we don't want to discourage hiring a qualified candidate, because optically, maybe it's an issue with who they're replacing, but we want to make sure that we have the evidence that we need to show that this was based on purely business reasons and for no other reason.
Great. And then I want to come back to one thing quickly. What are some of the claims that people cannot waive? Because I know that sometimes people say, well, I'm going to give this person this severance and I want to guarantee that they've waived every single claim, because I know there's claims under the EEOC and other things that we cannot waive. So can you just give us a list of what those things look like? Because I think people just need to be grounded in that a little bit, because a waiver is a waiver, but not a full waiver.
Sure. First and foremost, you can't waive claims that haven't come into existence yet. So anything that happens after the date the release is signed is not something that's waived. We don't usually see that, because that's usually the end of the relationship. But that's one thing that you can't release, is future claims. Workers' compensation claims cannot be waived. Claims for unemployment, I believe, in most states cannot be waived. One thing that's worth noting is, if there is a valid claim for unpaid overtime, for back wage, for failure to pay overtime or failure to pay minimum wage, those cannot be waived technically without court approval or Department of Labor approval. But we have some means to help with that, and it's basically language in the agreement that confirms the employee has been paid for all hours worked, that, if there is a dispute over overtime, that we're clearly identifying that in the contract. Because at the end of the day, perhaps they can still bring that FLSA claim, but they're not going to be able to get damages, and so there's no point in doing so. So those are the major claims that cannot be waived through a basic severance agreement.
Perfect. Well, being respectful of everyone's time, we've tried to cover off the questions that have been in the chat here, but if you have other questions, please don't hesitate to reach out to us with those. Both Anthony, the star of the show here, his email is available through our website, thompsonhine.com, as is mine. But if you're looking for employment answers, Anthony is your person. So that concludes today's discussion. The webinar was recorded and will be available to view in the library of recordings on Thompson Hine's YouTube channel. So hit subscribe, ring the bell, shoot us a comment. We appreciate that. Next month, we're going to cover off copyright and trademark, which is another hot button item that a lot of founders are trying to think about how to grapple with and what their rights are around that. Actually, we want to thank you for attending today's program, and a special thank you to you, Anthony, for all of your great content and responses. So we're super grateful for that and for your insights today. When the webinar ends, you're going to be prompted to give us some quick answers on a little survey. So we always appreciate Feedback is a gift, and we're always looking for ways to better these for all of the listeners as they march forward. So again, thank you. Appreciate your attendance today, and enjoy the rest of your day and stay well.
Thanks, everyone.
Thank you.